In today's courtroom, we're watching the sentencing of James Frank, a man facing his third domestic violence conviction. What makes this hearing so gripping isn't just the charge, it's how calmly the judge delivers consequences to someone who's clearly run out of second chances. Frank was initially facing a felony, but through a plea deal, he's managed to reduce it to a misdemeanor, domestic violence, second offense. Still, that leniency doesn't come without consequences. Watch how the judge walks a fine line between procedure and personal accountability. You'll notice, this courtroom isn't just about punishment, it's about calling out denial when it hides behind apologies.
Plea-based resolution today. Do we have a plea agreement, counsel?
Yes, we do.
We also have an amending count one.
And signed misdemeanor vice versa.
Mr. Gilbert, do you consent to the filing of an amended information?
I do have a copy in front of my client and myself, and we do consent.
And do you and your client waive the reading?
We do waive the reading.
All right, Mr. Frank, the agreement is for a misdemeanor plea here to an amended count one domestic violence second offense. All right, so do you understand did you read and understand the rights listed on the misdemeanor advice of rights form?
Yes, Your Honor.
And did you sign that form today?
No, yesterday, sir.
Okay. Do you have any questions for me or Mr. Gilbert about any of those rights?
No, Your Honor.
Do you understand that if you plead guilty, you will not have a trial and you'll give up all those rights that are listed?
Yes, Your Honor.
And is that what you're choosing to do today?
Yes, Your Honor.
Okay, the plea agreement provides in exchange for your plea to the amended charge of domestic violence second offense. The prosecutor will dismiss the original charge, which was the felony DV third. And there is a sentence agreement for 1 year in the county jail. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Mr. Gilbert, is that a full, fair, and accurate statement of his terms?
It is, Your Honor. Thank you.
Ms. Goodrich?
Yes.
Mr. Frank, has anybody promised you anything else?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
Is it your own free choice to enter that plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge of domestic violence second offense?
Guilty.
Mr. Gilbert, would you assist with a factual basis?
I'd be happy to. Sir, can you state your name for the record?
Frank.
And in May of this last year, were you in Sheboygan County?
Yes.
Were you at a residence with your significant other, I believe fiance?
Yes, Your Honor.
And that's Ms. Yates?
Yes, Your Honor.
And at some point in time, did you, you'd consumed quite a bit of alcohol, I believe. Is that correct?
Yes.
And did you end up in an altercation with her?
Yes.
At which time you physically put hands on her and were wrestling with her? Is that true?
Yes. Yes.
And she did not want to have, she didn't want to be touched in that manner or treated in that manner?
Yes.
And you agree that was without her consent?
Yes.
And again, that happened in Sheboygan County?
Yes.
And you have been in a dating relationship and a living relationship with Ms. Yates?
Yes.
I have no further questions, Your Honor. Thank you.
And
At this point, the plea becomes official. Frank admits to putting hands on his fiancée after drinking, something he's done before. It's chilling how routine the exchange sounds. Yes, Your Honor. Yes, Your Honor. Over and over, almost mechanical. This is what the justice system looks like when compassion gives way to exhaustion. His defense lawyer tries to frame it as a moment of weakness, but 3 convictions say otherwise. For viewers, here's the key takeaway: the court doesn't just look at the crime, it looks at the pattern. And when the pattern shows no change, mercy starts to fade fast.
Take in consideration the amount that he did not get credit for since his sentencing in district court. And I'd also, and we agree with the 1 year for immediate sentencing. We'd ask the court possibly consider allowing Mr. Frank to participate in the programs such as trustee or the GED program, or also I believe there's a CPT program. If the court would be interested in allowing him to participate in those, he would like to participate. Thank you.
all right, thank you. Mr. Frank, it's not required that you would say anything today, but it's certainly allowed. Is there anything you want to tell me?
Yes, Your Honor. I'm very sorry for what I've done. I know it's outside of my character to be like that, especially sober. While I'm intoxicated, I tend to take things a little too seriously and get out of hand, and I very much apologize for that.
It's the third time you've done it. Maybe you should consider whether it is part of your character and you want to do something to change your character. But to say, well, it's not in my character when it's the third time you've done it, sort of empty words, don't you think? I mean, you've done it 3 times at least, right? You've been convicted 3 times. Is that true?
Yes, Your Honor.
Okay, so don't tell me it's not your character. You do it 3 times, you're convicted 3 times. It's part of who you are. Change who you are.
Yes, Your Honor.
Here's where the tone shifts. The judge finally calls him out. When Frank says, "It's outside my character," the judge snaps back, "You've done it 3 times. It's part of who you are." That line hits like a gavel strike. This isn't just legal reasoning, it's moral confrontation. The courtroom goes silent, and you can sense the weight of truth landing. It's a powerful example of how judges sometimes have to speak beyond the law to make offenders face themselves. The real question for viewers: do repeat abusers ever truly change, or do they just get better at apologizing?
There's $50 in state costs, $75 in the crime victims assessment, $350 in court costs for $475. If you fail to make reasonable efforts to pay that by by paying that when you're released, then you'd be subject to contempt of court. I kind of hope you don't pay it, so then I can give you 93 days contempt. So give me a reason to give you more jail, and I'll be happy to. Otherwise, if you don't want to give me a reason, you want to pay that the day you get out. You understand me?
Sure.
All right, you can file an appeal if you wish by filing an application with the Court of Appeals. If you want a lawyer, I'll give you one, but you have to ask me within 6 months. We're going to give you a piece of paper explaining that appellate process and ask you to sign 1 copy or initial 1 copy. So we have a record we gave it to you. And the other one is fill out if you want to take an appeal. I have not really dealt with you in the past, Mr. Frank. I will remember who you are. And every time I get a chance to lock you up, I will do so. Good luck to you.
Oh, Your Honor, is the I know the victim asked me in the hallway, and I think he's asked the prosecutors, the no contact with him.
He is not on, now that sentence has been imposed, he is not on bond and he's not on probation with me, so there are no conditions.
Thank you very much.
All right, we'll stand adjourned.
The sentence is firm: 1 year in county jail. No programs, no early release, no leniency. The judge even says, "If I see you again, I'll lock you up every chance I get." That's not anger, that's finality. It's the sound of a system tired of giving chances to someone who won't take them. This hearing reminds us that domestic violence cases aren't just about punishment, they're about the community's breaking point. If you found this breakdown insightful, make sure to like, share, and subscribe for more real courtroom moments where justice speaks louder than excuses.